Mr. Okon, in this case, how many witnesses are you going to fill in? How many witnesses are going to call? One witness, okay. Haven't you seen it? It's not there. The witness statement of witness statement on oath for the defendant. How many volumes of this file? Only one volume? You can call the case now. Yes. Okay. Clement is present. Okay. Hold on. Appearances. Announce your appearance.
The claimant is present.
Yes.
The defendant is represented by Mr. K.S. Nwakana.
Mr. K.S.
Nwakana.
Present, my lord.
NWA. What is your position with the company, sir?
Okay, legal officer, my lord.
Legal officer to the defendant.
Announce your appearance.
I, Ezugo, because Ezugo is spelled E-W, G-W-U. My appearance is for Clement.
Yes.
I'm grateful.
Yes.
Great man.
Yes.
My name is Okon Uye.
Yes.
Would be his banana friend, Damilola Aderoye.
Adewoyu. A-D-E. R-I-N. Aderinoye. for the defendant. Very well. I'm sure Ezugu, but say Ezugu is also ready. Yes. Yes. Yes.
So his name is Mr. Basket.
Let him speak to the court.
Witness. Hello, witness.
Good afternoon, Your Lordship. My name is Ekere Basi. I work as a group human resource manager for
He's not
Nurture.
getting you.
Yes. He said no Muslim.
Mr. Bassi.
Yes, sir. Your
Yes.
Lordship. My name is
Before introducing yourself, I think listen to the register of the court is going to administer oath on you.
the audio is relatively poor at my end. I can't hear him very well. I'm sorry. I wish you could approach the mic. Could be closer to the mic, please.
Mr. Bassi, are you a Christian or Muslim, sir?
I'm a Christian.
Please. No, sir. Can you see this and read?
Oath for Christian. I, Ekere Basi, swear in the name of Almighty God that the evidence I shall give in this case shall be the truth, the whole truth, and nothing but the truth. So help me God.
That's why we join the
Yes.
Yes. Witness. Can you hear me clearly?
I know you are speaking, Mr. Okun Uya,
Yes. Can you
but not
hear
very
me?
audible.
Yes. Please tell this honorable court your name and what you do for a living.
My name is Ekere Basi. I work as a group at Human Resources for Notori Chemical Industry Limited.
Thank you very much.
Yes.
Sometime in November, on the 25th day of November 2024, you went before the Commissioner of Police, National Industrial Court, Abuja, to make a statement. Is that correct?
You are very correct, sir.
Yes. I have the witness of the witness statement on oath in my hands now. You can see it.
Yes, I can.
Yes. What do you want to do that statement that you made?
I would want the court to adopt it as my evidence in this case.
Thank you very much.
Very well.
Yes, please.
Hold on. The witness statement on oath deposed by the witness on the 25th day of November 2024, having been identified and adopted by the witness, is hereby taken as the evidence in chief of DW1 in this case before this court.
Copy.
You have influenced him. He has already succumbed to you. I know he's not going to have any cross-examination at all. Okay. Yes.
Witness, in your statement of oath, you have referred to a number of documents. I will have handed it over to you for you to look at it. And that they are here in my hands. I don't know whether you have copies of you there.
You don't know if I have what, please?
The copies of the document you referred to in your witness
Yes,
statement.
yes, I do.
I can look at.
Yes, I've seen it. I have it in my hand.
How many of them?
I just eight. Man's data. Dependence of the terms of payment. Claimants, companies, capital incorporation, facilities. Claimant company change of name. Memorandum and article of association of all. And then NS and C assessment. Yes. Yes, please. Some of the documents here are Most of them are photocopies. What do you have to say to them?
I can hear you, sir.
These documents are photocopies and documents printed from online and all that. What do you have to say to that? How do you get all of that?
Yeah, there are documents that were printed from my computer in my regular course of work. The computer is in a good state, and they are from sources I would ordinarily rely on in discharge of my responsibilities. So I consider them valid to be used.
What of the photocopy of your response, the September, the letter of 10 September 2020, the photocopy of the letter addressed to your company, to the lawyers, to me?
Could you please maybe move closer to your mic, please? I can hear photocopies.
I have a photocopy of a letter addressed by notary to the lawyers, to the claimants. Where is the original?
Of what date? Is it dated?
September 10, 2020.
The original should be with him.
The claimants.
Yeah.
Thank you. So the document in which you printed from the computer, the online document relates to certificate of incorporation, statement of accounts, and certificate of incorporation and change of name of Mark Crystal Accounting. Is that what they are saying?
Come again, Council. Certificate of incorporation, statement of account.
Certificate of incorporation of MC Crystal Consulting Services.
Yes.
Then certificate of change of name to MC Alpha Consult Limited. Those online prints in relation to those documents.
Yes, those documents were printed online from the source of the issuance of those documents, and we wish to rely on them.
Thank you very much. I seem to turn that to something to ask.
Since there have been no objection by the claimant's counsel to the application to tender in evidence by the defendant's counsel, these documents having been identified by DW1 are hereby admitted in evidence and accordingly marked as exhibits D1 to D8 respectively. They appear in the manner listed on the list of documents filed before this honorable court by the defendant. Yes.
Mr. Witness, what do you want this court to do for you? Mr. Witness, can you hear us?
He has muted himself even.
Mr. Witness, can you hear us?
Maybe he's struggling to come back again.
Yes.
He has resurfaced. Mr. Bassi.
Yes, sorry, I lost my network, so I'm joining from
Yes.
a different device.
All right. Mr. Witness, what then do you want the court to do for you?
I would wish
Mr. Bassi.
that the court should throw out. Yes, I can hear you now.
Yes, okay. Counsel, he can hear you.
Okay. Yes, so I would wish the court to throw out the claimant case for lack of validity or merit.
Thank you very much. That is the evidence in chief of the defendant.
Any cross-examination?
Yes.
How many minutes do you want to take for the cross-examination?
It will not be more than 30 minutes.
30 minutes.
By God's grace. Subject to the witness cooperation.
Absolutely.
Sometimes they will not want to cooperate. In terms of asking questions,
Anyway, 30 minutes. What time are you stopping? It's now some 10 minutes past 2.
By 3:40. Sorry, 2:40.
Yes, by 2:40. Yes. Yes, you can go ahead.
Yes. Witness. Mr. Bassi.
Sir, I'm listening. I can hear you, sir.
You are the legal officer of the defendant. Legal officer.
I said I'm a group human resource.
Human resource.
Yes, sir.
Please take the court when you were employed by the defendant.
I was employed in August 2013.
August
2013.
2010.
13. 1-3.
One page, August 2013.
Yes.
And I apply for. Let me get my money.
Yes, oblige.
Even though I've tendered that same document before.
Which document is that? Which document is that I asking for?
Letter of employment.
Okay. Oblige. That's C1.
It was tendered earlier as CW9, but now
C9.
it's tendered again.
Okay.
Yes. The document you just tendered to court now and we need to letter of employment of the claimant.
Yes, can he hear you? Mr. Bassi.
Mr. Bassi, can you hear me?
Hello? Yes, I can hear Mr. Bassi. Can you hear me now?
Me. It was not from that source. It was not from you. Hello, Mr. Bassi. Can you hear me now?
I can hear you now. Yes,
Thank you.
I can.
Thank you. Yes, the document you just tendered now, letter of employment of the claimant. Before your engagement as the human resource officer of the defendant, it was one Onome Agomate that was the human resource officer.
It was?
One Onome Agomate.
She was the head human resources and not human
It was
resources.
the head human resources.
But I can hear you now.
So I'm right that
Yes.
before your engagement, it was Onome Agomate that was the head of human resources of the defendant.
Loud and clear.
This witness, you settle down now. Settle down. It's not the same person. It's not the same person there.
Is the
He's
same
struggling with
person.
network.
This is me. I should be spoiled.
Who is KS Wikana? Who is KS?
That's a legal officer.
Yes, if you can hear me, before your employment in 2013, it was Mr. Onome Agomate that was the head of human resources of the defendant.
Miss.
You are correct. I think I answered the question earlier.
That's right.
Yes. He was the one that signed the letter of employment of the claimant.
You are correct. Yes. I'm answering you. I said yes.
Yes, the court is right. I know you are answering me.
I'm taking down.
The court is taking down what you are saying.
Sorry, sir. Sorry, sir.
Yes.
Yes.
Notorious Supply and Trading Limited, British Virgin Islands. is a subsidiary of the defendant.
British.
Moribond, yes.
Notorious Supply and Trading Limited, British Virgin Island, is a subsidiary of the defendant.
Was a subsidiary of the defendant, yes.
Yes.
The defendant owns 100% shares of Notorious Supply and Trading, British Virgin Island.
Don't have information on the percentage of Notorious holding on that company.
You don't have information?
I don't have that information.
As the cop pleases. May I apply for SBIT? SBIT. CW18. Sorry. I'm sorry, my lord. CW13.
CW13. Yes.
Have you ever, in your position, came across the share certificate of Notorious Supply and Trading, British Virgin Island? Yes.
Have you ever come across
The share certificate
The share
Across
certificate
what?
do not have
of Notorious Supply and Trading Limited, British Virgin Island, BVI?
in my position as the head of Group Head Human Resources and based on my everyday activities, the certificate of that company does not necessarily have to come through me and doesn't pass through me. So I have not come across it in the course of my daily
I
job.
said, have you ever come across that share certificate?
I am saying that based on my job role and scope, that is not a document that comes to my table as part of my job ordinarily. So I have not come across it.
He said I have not come across it.
He said he has not come across it.
Can you confirm that that share certificate exists?
Cannot confirm.
Can you confirm that that share certificate exists?
I had said that based on the scope of my work, those are not documents that ordinarily comes to my table, and I have not come across it. So if I have said I have not come across it, I cannot confirm that it exists.
All right. It's okay. Now you have admitted to this court that Notorious Supply and Trading is a subsidiary of the defendant. Can you tell the court the level of shares the defendant has in that company?
I think I've answered this question before, but again, I will reiterate
You have not
it.
answered it.
I do
Hold on,
not.
witness. You have not answered it. You have
Can you
admitted.
tell?
You have admitted. Don't listen to me. I make it easier for us. You have admitted that Notorious Supply and Trading is a subsidiary of the defendant. Now I'm asking you, do you know the value of shares the defendant has in Notorious Supply and Trading?
And I said, no, I do not know.
You don't know. in exhibit CW9. Sorry, exhibit D2. But Lord, I want to refer to the exhibit. Exhibit D2. Exhibit D2. Do you have a copy of it there?
Could you give a title to the document?
Letter of employment.
I've seen a photocopy of it.
Yes, you have a copy. Page 2 of that document. Page 2 of that document. Can you read to the court here the paragraph on deployment?
Could you come again?
In page 2 of exhibit D2, can you read to the court the paragraph on deployment?
You may be deployed to any division within the Notori Chemical Industries Limited or any company in which Notori may have interest and in any part of the country as deemed necessary.
As a couplet. You will agree with me that upon employment of the claimant, he was deployed as financial controller for Notori Supply and Trading Limited, British Virgin Islands.
He was
deployed as financial controller to Notori Supply and Trading Limited, British Virgin Islands, UBI.
I would beg to differ with you because based on paragraph 1 of the offer of employment, it is stated.
This is not examination in chief. This is cross-examination. So you have to answer my question. Now,
I would say, okay.
Giving earlier answer on that deployment. And I said, when the claimant was employed, he was deployed to Notori Supply and Trading, British Virgin Islands.
I said I disagree. Okay, my answer to that is that I do not agree with you.
As a company.
yes.
Yes, my Lord. In your paragraph 9 of your statement of oath, you said Notori Supply and Trading Limited is an autonomous company different from the defendant. Is that correct?
Yes.
Do you have any letter? Do you have any letter from that autonomous company employing the claimant as its staff or employee?
Do you have any letter?
Any letter? Yes.
I wouldn't have such a letter because I do not work for that company and I don't have a relationship with that company.
Do you have any
Do you have
letter?
letter from Notori Supply and Trading Limited? He said it's an autonomous company.
I do not have any such letter because I have no such relationship with
that company.
Yes.
Now, that means everything you are saying, everything you have said on your statement on oath about Notori Supply and Trading Limited was not but what you were informed.
So it is correct to say
yes,
that all what you said
in his oath
on oath
about Notori Supply and Trading Limited,
about Notorious Supply and Trading Limited
is on the basis of what he was informed, not what he knows.
On the basis of information
Yes. We got.
passed over to you. What's your answer? It's not there again.
Is there.
My answer, I'm here. My answer is that information, whether the source of information and knowledge, can be intertwined. If I was informed, read about, see records. My question is, my answer. Sorry, sir.
Mr. Bassi, hold on.
Sir?
You have said you don't have any knowledge about notorious supply and trading. That is the last answer you gave. And I say, so that means
That was not the last answer I gave. I beg to differ, please. That was not the last answer I gave.
What? You are repeating the question? I repeated the question.
Because he's trying it again. He's not answering my question. What I'm saying is that I've asked him based on paragraph 9 that it's an autonomous company. Does he have any letter from that company engaging the friendly claimant as a staff? He now says he doesn't know anything about that company.
That was not what I said. No, that was not what I said.
No, he is making a clarification to the court, because even myself, I could not even record the question. I couldn't get the question here, sir.
That is misleading. It's misleading. What the witness said, he asked a question whether the how he, being an autonomous company, whether he has any data of paper. And he said, I do not work for notorious, so I don't have any data. So he is not saying that the man said something different. What he said that he doesn't go.
He's entitled to ask the question. Yes. You can ask that question.
But no, he said he doesn't know anything about the company because he doesn't work for the company. And I'm asking, that means, that was the follow-up to my question.
Yes.
That means everything he has said here, I know where I'm coming from.
Yes.
Everything he has said here was based on information passed to him. So is that for him to answer? Yes, no, it is not. Because I'm going from where it's coming from. Don't wait, this is condemnation. You have done your job.
He said,
he's not to mislead the court. He's not to mislead the court. The witness, because he's now saying, he's telling, we're asking the witness.
Counsel, there is no point of interjecting. The question he said, so it is correct to say that all what you said on oath about Notorious Supply and Trading Limited are on the basis of information passed over to you? That's what the question he said.
The question is on the wrong premise that the witness said. Another question.
You have passed that premise. Because I'm sorry, my friend is taking time to give to his client. You have passed that stage.
Allow the counsel to do the cross-examination.
As the court pleases. As the court pleases. It's not for him to say, he has the right to say no. Let him say no. It will be on record.
However, the witness has said that my sources of information and my knowledge are intertwined. He told that you objected to that. You said you should answer your question.
Yes. And the question I asked him is that, having said he doesn't know anything about, he doesn't work for Notorious Supply and Trading Limited. Because of that, he doesn't know whether there's a letter of employment. I now ask him that the information on the deposed to here is based on information passed to him. And I want you to answer that question.
All the information I have given is based on records available in the company.
As a company, I'm grateful. Let me remind you that you are on oath. Even though you are not here, you could still be sued for perjury.
My Lord, you shouldn't present my client.
Not to him.
You shouldn't present my client.
Yes.
It's a threat.
It's not a threat, my Lord. I'm only reminding him that he's on oath and implications of lying on oath. I'm not threatening him. It's not a threat anyway. It's how you calm down your friends today.
That's why I'm asking you not to threaten the witness.
Now, I have limited time.
After all, as a migrator, you're sharing the same seat.
Now, the record we are talking about, is it the record of Notorious Supply and Trading Limited?
The records you are referring to?
Yes. Is it the record of Notorious Supply and Trading Limited, British Virgin Islands?
Is it the records of Notorious Supply and Trading, BVI?
Yes.
What's the answer?
As a result of my position as head of human resources, all staff records.
The record you are referring to, the council is saying that record you have made
all staff records.
That it was based on the record, available record.
Yes.
Which records are you referring to? Is it the records of the NS&T, BVI?
Records of Notori Chemical Industry PLC Limited.
Record of, I'm grateful, Lord.
Notori.
That's the defendant.
Yes, that's the defendant. And let me please save my time by interjecting. Now,
he will not interject.
Yes, I'm grateful. Witness, that means you don't have any record of Notorious Supply and Trading Limited, BVI.
The records I have are the records I have deposed.
I'm saying it now clearly. Answer it in the affirmative or the negative. You don't have any record of Notorious Supply and Trading Limited, BVI.
I do not have.
You don't have.
Except what I've given out.
It's okay. By the end of this examination, the court will see you, and the witness has not come to tell you. I'm not threatening him. Now, if you don't have this record, like you have said, that means all you have said in your statement of oath about Notorious Supply and Trading Limited was information you obtained from third parties. Protect me.
I will still have to. He should not say what they witnessed. I said, I have what I have is a report that I have given to the witness. You know that all the records. You don't know what we show you have the record of the. He said, all I have is what I have given out to the court. That's what he says.
I think that's nothing wrong with this question. The question being asked, if you don't have these records, then all what you said are information you got from third parties. Then let him answer. Let the witness answer that.
The writer there is
Mr. Bassi. Mr. Bassi.
Yes, my lord.
He has that question. He has before the court. He said, what I have of the court is what I have is what I have given.
Let him say that out again.
Yes.
Okay. All the information I've given in regard to this case are based on record available in Notori.
Hold on, you're obstructing, in fact, the court. What are you saying?
I'm saying the information as given are based on records in Notori.
You have said that. That was actually what escalated the series of questions that follows.
Because in your evidence here, you have said a lot.
Let him answer this question.
Yes, you have to answer it.
If you don't have these records, then all what you said are information you got from third parties. What is your reaction to that question?
Based on records available in Notori. I don't know who third party is. I'm referring to information available in Notori.
Based on records available from Notori Supply and Trading BVI.
No, you say no. You say you don't have that record. Sit down. He is before me.
I can get that one cleared. Based on records available from where?
In the claimants,
From where?
claimants, notary.
Based on records from where? Based on records from where?
Records from notary, the claimant. The defendant, sorry, the defendant.
Very well, very well. That's notary chemicals.
Yes.
I must pin this witness down to this question, no matter how hard he tries to avoid it. And that comes to my next question. Because I'm grateful. The record you have with the defendant, does it include the record of Notorious Supply and Trading Limited, BVI?
I didn't get that.
The record you have with the defendant, does it include the record of Notorious Supply and Trading Limited, BVI?
The previous name of the company before it was changed?
No. This witness should answer people question. Because you see, I've asked him now. He said the record. I said that record. Is it include the record of Notorious Supply and Trading Limited that he has?
Does it include it?
Does it include it?
Yes or no?
Does it include? If it includes, tell the court, yes, it includes. If it doesn't include, then you tell the court it doesn't include.
The record I
It's a
have,
straightforward question.
yes, that's what I'm saying. The record I have is the record that shows the incorporation of that company in 2008.
The records I have are those showing the records of incorporation of the company in 2008. That's your answer.
Yes, because I'm grateful. Now, you don't have the record of any letter written by Notorious Supply and Trading Limited, BVI, employing the claimant.
Did he have what?
You can't be this smart. I'm sorry to use this word. You said you have only the certificate of incorporation. I now want to bring it closer that you do not have any record of Notorious Supply and Trading Limited, BVI, employing the claimant.
Yes, I do not.
Yes. That's where we started from, dodging from.
Except I'm not, okay.
It doesn't have it.
You are working. You don't need to interject by making remarks as such. Such a remark will now escalate some other thing that will come. And
I'm so sorry, my lord.
We want to have a good record.
I'm so sorry, my lord.
Is that all? Or you have more questions?
You have more questions, my lord.
And your time is really.
My lord, my friend.
In your paragraph 16, you said, paragraph 16, you said the obligation of the claimant and defendant.
Could you come closer? Could you please come closer to
the obligation of the
have a very loud voice.
Claimant?
Yes, closer too.
You need him, so he has asked you to bring your own closer. So obey him.
As a complete this.
Yes.
As a complete this. Now in your paragraph 16, you said the obligation between the defendant and the claimant was discharged in February 4, 2009. Is that correct? 2009.
Let me reaffirm, please.
Paragraph 16 of your evidence. You said the obligation between the defendant and the claimant was discharged in February 4, 2009.
Yes.
Paragraph 12. Paragraph 12 of your written statement of oath. In paragraph 12, you said the defendant commenced discussions with the claimant up to 2019. Paragraph 12. Is that correct?
I've seen what you have. Yes.
I should be protected from Mr. Uye. Mr. Uye is taking this in too far.
My problem with my learned friend is that he is trying to take the advantage on the defendant, on the witness. But the statement is that you read the paragraph 12. You cannot just go and read the portion. He's not reading whatever. He doesn't have the document.
He has answered the question.
If he wants him to answer the question, he should read everything in paragraph 12. The witness can have the benefit of what he's talking about.
Very well. Counsel, if you have not read it out.
Read out everything there.
Read it out. If you want to answer your question, read it out as a base, as a foundation for your question.
In paragraph 12, I read it to you that you said the defendant commenced discussion with the claimant sometime in 2019 on the scaling down of the operations of NS and TL, as the subsidiary was no longer able to generate trade and income to sustain itself.
To the extent that the defendant had to change some funds to bail NS and TL out of financial crisis. My question is that as of 2019, don't interrupt me. As of 2019, the defendant was still in discussion with the claimant. Yes. Defendant was still in discussion with the claimant.
That was still in discussion.
Yes.
Am I supposed to respond?
Yes.
Okay. So I can't see. I'm struggling to see the link between paragraph 12 and paragraph 16.
This is not an essay. It's not an essay. We are not writing a thesis here. It's a simple question, yes or no.
The two paragraphs are very explicit. In paragraph 19, they were in discussion to the extent about the winding down of the business. In paragraph 12, rather, they were in discussion with regard to winding down of the operations of supply and trading. In paragraph 16, we're speaking to the employment status based on the employment letter that was issued. So I don't know.
Well, the point is that as of 2019, they were still in discussion of any sort whatsoever. Yes. Before you please help me, but your interruption is disturbing me. Now, as at today, because that will be I'm scaling down my question because of time. I am, as at today, that you are giving evidence. You don't have any document from the record of the defendant that they've terminated the appointment of the claimant.
Yes.
I'm grateful.
Also, you have eaten more than you can chew.
Yes. As of today, too, you don't have any record from Notorious Supply and Trading Limited.
You equally have no record
From Notorious Supply and Trading Limited, BVI.
Yes.
That they've terminated the appointment of the claimant.
What's your answer to that? Mr.
As
Bassi?
earlier said, I do not have any record about the termination of the employment of the claimant in this case.
Please.
Council, I think you have come to an end.
No, my lord.
Your time is off.
No, my lord, I'm sorry. Those 5 minutes. Those 5
No.
minutes. Because my fellow friend really took over 10 minutes.
You are taking more than the, I mean, the
Lord,
time,
Lord,
the time, the
I'm
time divided for
going to
under
talk at 2:40.
Yes.
I'm going to talk at this is too. Sorry, I'm Lord, I'm sorry, just 5 minutes.
You have taken about 40 minutes. You have taken 40 minutes.
Now, with this, in paragraph 23 to 30, you talked about fraudulent transaction of the claimant.
You talked about
fraudulent transactions of the claimant.
fraudulent transactions
of the claimant.
Of the claimant.
To the defendant. You don't have any record of any query given to the claimant by the defendant.
Those records will not come to me because it's not my staff.
The defendant does not have any record of any query. If you don't have it, the defendant does not have any record of any query given to the claimant.
He is not, yes, the claimant is in my staff, so I won't have that record.
I don't have that record.
Because it's not his staff.
Yeah.
Those records will not come to me because it's not my staff. Finally,
you also don't have any query from Notorious Supply, any record of any query from Notorious Supply and Trading, any available record from Notorious Supply and Trading, BVI.
Yes. Yes. Witness. Mr. Bassi.
Yeah, the last record was the last statement, please.
He said you have no record of query as well from Notorious Supply and Trading, BVI.
Yes, I said so because the person involved, disciplinary issues are based on company basis, so I wouldn't have those records. It's not my staff. It's not the staff of the defendant.
Now, to the best of your knowledge, the claimant has not been reported to the UK Metropolitan Police over any case of fraud involving the company.
To the best of your knowledge, was the claimant
be reported to the
has not,
UK Metropolitan Police.
Has not
be reported to the UK Metropolitan Police over any case of fraud by the defendant or even Notorious Supply and Trading Limited, BVI. To the best of your knowledge.
Over what?
Over case of fraud.
To the best of my knowledge, I am not aware, but there are evidence of withdrawals in the account that are not, that there's no evidence for.
That's not what I reported. I think the case has not been reported to police. That was my question. I'm not talking about our account.
To the best of my knowledge, I don't have any information with regard to report to any police, but for the best of my knowledge, there's evidence of the claimant unauthorized and withdrawals from the account.
My question is, to the best of your knowledge, the claimant has not been reported to the UK Metropolitan Police over case of fraud by the defendant.
He said, I'm not aware. However, the claimant, you said, however, the claimant what?
There are evidence of the claimant unauthorized withdrawals from the account.
There are criminals unauthorized what?
Withdrawals.
Withdrawals of funds from where? From where?
You are muted.
Oh, from the accounts of NS and TL.
But you have no access to it. You don't know it.
Is that the council?
My claimant, my client, I'm so sorry. I don't know why I asked you. That's quiet. Now,
council, you have
just because of this last question you answered. That unauthorized withdrawal you are talking about, there is no query on any letter of any query concerning it that you have.
As I stated earlier, yes.
As copies. Now, just this last question. Last question, Lord, and I'll leave it. The discussions you refer to in 2019, in paragraph 12, between the claimant and the defendant, that discussions were carried out via electronic mail.
On electronic
mail. Yes.
Is that right?
Is that right?
Yeah, I know you said something about electronic mail.
Yeah, I said the discussions we referred to in paragraph 12 between the defendant and the claimant, that discussion that went on was through electronic mail.
I don't have that information.
Now, take the course. How did they discuss? Because it's your word I'm using now. What was the mode of discussion? Take the course. What was the mode of discussion?
I stated in the paragraph. The defendant commenced discussion with the claimant in July on scaling down of the operation of the business.
What was the mode of discussion? That is the question. Human resource officer, what's the mode of discussion?
The discussion was between the
How was this
operator.
carried out? Was it by call or by messages?
The discussion was between the claimant and whoever was taking care of his operations, overseeing his operations.
Witness, my question is simple, and this is the last question. You have said there were discussions between the claimant and the defendant in 2019 for scaling down whatever business. How was this discussion carried out? Is it via phone call or via electronic mail?
Like I said earlier, the records available shows that there were discussions.
He knows what he's doing. He caught me clearly.
And he has answered that the records available show that.
You don't have any record before us.
Any re-examination?
No.
I want to thank Mr. Emmanuel Senior. I must pay this bill for making it possible for us to end this case today. I was actually afraid that they will not have their witness in place, but I'm glad that when I came, you confirm that
I think what I want to say, we want to say something. The records of this court we have been very, very good.
Time has come when you people are going to address the court. So if you have anything that you feel you want to bring it, to light before the court, then you can do that. That's why you have this opportunity to address this court. Don't worry. So defendants counsel, is that all for your case?
We take guide from the rules.
For the time being, is that all for your case?
Yes, that is our defense. I just want to make it enough. Not for the purpose of what we have said in the conduct of this case. However, the record is true that there is no one adjustment other than business from inception. So the record is true.
That's
what also show that this matter was struck out because of the kindness and claimant.
Okay.
It's good that the thing has come to, but I have a history of legal, that once I'm doing a matter, be very diligent in matter. And that's helped me for a good number of years, at least for 34 years. It's been like that. So it's not just yesterday. And I do sometimes take exception to when my Ghana friend has some comments that is inconsistent with the legal professional. No, I didn't want to join issue with him because we've gone beyond the point that we have to pick our fights and to know what to respond to. So I'll leave it for him. I'm sure by the time he grows up, to some age that we are, we then understand that some of those comments are inconsistent. I'll leave it at that moment. Now that the matter has ended, we'll check on this, on the rules, and find our final analysis. Ask them more of them. Thank you.
No, there is this principle of that witnesses don't put their character in issue so that you don't expose.
Counsel, you don't need to join issues on issues. This until this, in fact, it has no basis, in the conduct of this case. So let's go to the business of the court by. I will now give you time within which you will file your final written addresses and reply if any. Yes.
I still want to thank you for making it faster. I think it should have even been a part of the back for that application. As I'm saying that we are not saying the truth. I thank him, my senior colleague. I look up to him sometimes, and it's not in him that it is perfect. Anybody can care. In fact, I was really surprised that he came today because for the about 3 4 adjournments, he has not been coming. So I was thinking maybe another senior captain. So we not really know actually what happened. And then we even find an for even the amendment after we have opened our case and closed our case. No time to say this, stop delivering on after this country. We start back on that. I'm Lagos. When it comes to that, I know what I do for me.
You have his lunch, I can assure you.
Since it is a virtual trial, wherever he is, he's still part of us. And I'm sure he's comfortably seated. And both of them, as I can see them, some are even leaning behind, very well. So, in principles, but the witness DW1 can step down, and you can leave the meeting. Thank you.
Thank you, sir.
This case is hereby adjourned for counsel to file their respective final written addresses and reply, if any. Accordingly, the defendant's counsel is to file his final written address on or before the 12th day of July 2026, consequent upon being served, the claimant's counsel should proceed to file his own written address in not more than 21 days, which shall expire on the 2nd day of August 2026. Thereafter, 7 days be available to the defendant's counsel to file his reply on points of law, if any, which shall expire on the 10th of August 2026. A date will be communicated to both counsel by the registry of this honorable court for address. While filing your final written addresses, counsel should file soft copies alongside the hard copies into an email to be provided for by the registrar of this honorable court. This is the ruling of this court. So until when you conclude filing your final written addresses, then we will issue a date for adoption.
Okay. I want to come to court for a lawyer. You can take it court.
Very well.